Do you have a plan for your assets and property when you pass away? It may be uncomfortable to think about, but your things, money, property, and sentimental items will be passed on to someone when you die. One way to ensure things go where you want them is by using a will. A will is a legal document that contains your direct wishes for your property, assets, as well as the care of your dependents. If you do not create a will, then your property will be distributed by a probate court according to the laws of that state. Each state will have different laws regarding the distribution of property for the deceased. A will allows you to specifically state what you would like done with your property upon your passing. You can state who receives specific property and perhaps more importantly, who will not receive specific property. You can also state your wishes for who should take care of your dependents upon your passing. Types of wills are a written will, which must be witnessed, a holographic will, which is written but not witnessed. It is not valid in all states and it must meet certain requirements. Another type is an oral will, which is a spoken will. And the final type is a pour-over will. The details of each type of will is outside the scope of this video. Having a will does not allow you to avoid probate, so remember that. And probate is the process of distributing assets to your heirs according to state law. But having a will does provide a method for distributing your assets according to your wishes. Part of the probate process will be proving the validity of the will and then transferring the assets accordingly. There are certain items that are not covered by a will. And the first one is accounts with beneficiary designations or deemed transfer on death. So these accounts would be bank accounts, investment accounts, retirement accounts, annuities, and life insurance policies. Another item not covered by a will are assets that pass through by law. So this is going to have to do with how it is titled for ownership purposes. So this would be with rights of survivorship, joint tenants with rights of survivorship, and any property owned tenancy by entirety. And then the final item not covered by a will would be assets in a trust. So this is property owned by a properly drafted trust. When considering how you want to distribute your property, a few things to think about are state laws. Is it community property state versus a common law state? Also, probate court laws vary state by state. And then finally, real estate owned in different states may be subject to different laws. To create a will, you have two main options to choose from. First, you can go online. There are many reputable companies that offer will-making services online. They're going to help you guide you through the process of drafting a valid will. Their services may be more generic, and the trade-off is that it might be potentially lower cost to use them. The other option is going through an estate planning attorney, and they're going to be able to help you draft a valid will. They can guide you through the process, and they may be able to provide a more personal approach. Their services may be more comprehensive, but the trade-off may be a potentially higher cost. Whichever option you do choose, know that having a qualified estate planning professional or company help draft a will can ensure that your will is valid, and it meets the wishes upon your passing. For more information on creating a will and other estate planning questions, please contact a qualified estate planning professional. For more personal finance content, please check out our website and follow us on YouTube. As a reminder, this video is provided for general education purposes only. It is not intended to provide financial advice specific to your situation.